From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Hope you're having a good Wednesday afternoon. I'm Lori Tucker, along with our legal analyst, Greg Isaacs, and we're happy you joined us today because, well, here's one thing, Greg, and it's always good to see you, by the way.
Good to see you.
Got to get that out of the way. Did you Google us to find us? Will we still be able to Google, or will we have other options? There's a major decision that was made in court on Monday, and that's what we're talking about today.
Landmark decision.
Yeah.
An antitrust case was filed against Google in October of 2020. Very interesting. It started with the Department of Justice, 11 states. In December, 38 other states joined, including Tennessee. And the allegation was that Google had a unfair anti-competitive advantage. They created illegal monopoly. And the judge ruled Monday that they did.
So what does this mean going forward?
Wow. So this case now goes into varying stages for damages and a finding that there was a violation of the Sherman Antitrust Act. It was in 2004 with Microsoft and Windows.
And that affected Microsoft.
It hit them hard. But, you know, if you fast forward to this lawsuit and the facts, you know, Google is in a perceivably a stronger competitive advantage / legal disadvantage than Microsoft was.
It's more of a monster if you want to look at it that way.
It's not only anti-competitive, it's a 800-pound anti-competitive.
You want to find anything
gorilla.
out, you go to Google.
And let's think about this. So to have a unfair monopoly or competitive advantage under Section 2 of the Sherman Antitrust Act, you have to prove that the company engaged in monopolistic behavior, and that means the behavior could be one of two things, exclusionary or predatory. And in defense, you can say we had a pre-competitive advantage, so there are certain things that we do that nobody else can do. We have an innovative product, we have advantages in terms of the market share, and that can change things and be a defense.
They had their tentacles everywhere.
They did, but what is interesting about what the district judge in Delaware said, there is very little evidence, direct evidence, that Google has intentionally engaged in monopolistic behavior in violation of Section 2 of the Sherman Antitrust Act. But it's kind of like if it looks like a duck, walks like a duck, it's a duck. And let's look at the numbers, Lori.
Okay.
So the main thing is Google invests most of their money not in R&D, research and development, in default contracts. So what it's interesting. So in 2026, they paid our friends at Apple for their computers and smartphone $26 billion to be the default search engine on the computers and the phones.
Isn't that just doing good business? And how would that hurt the consumer? For me or for anyone out there, I'd like to hear you guys weigh in. Isn't it easier just to go, Google, get your answer?
Well, and that's what Apple has said and Google has said, hey, we're simply just better. But look at these percentages in whatever. Google controls 90% of the computer market as the default search engine.
I believe that.
Smartphones, 95%.
Wow.
The next 800-pound little gorilla, Microsoft, they control a mere 5%. So what the judge has said, you know, even if you're not intentionally doing it, you know, because you have so much of an ability with your name recognition and your ability to pay more money, that it could rise to the level of anti-competitive behavior. But really fascinating. But here's what's going to be amazing as now they shift into this next phase.
What could happen here?
They could make them limit their amount of default contracts, that you can't be the exclusive provider for Apple.
But then wouldn't that hurt the consumer?
You know,
who's the winner here? Other companies, obviously, that want to jump in and become a search engine as well and make money. But how does that benefit us?
Well, that's the question from Google Earth.
Yes.
As we're looking at it from on high, you know, is I guess from a pragmatic standpoint, and
Yeah.
if you have to look in the
We do have
judge
to look at the
has
law
to do
here.
a cost-benefit analysis. Is this a unique situation? When we look at the Sherman Antitrust Act, I think that's when, back when they were, the executive branch was not happy with the railroads and their monopolies, and so we created a law to battle that. But maybe we are to a point where monopolistic behavior is a good thing, because should Google be punished because they're too innovative? There's something we rely on. But then again, the judge kind of noted, well, but really why you're so successful is no one else can pay $26 billion to have the exclusive default contract.
But whose fault is that?
Well, that's a good question. So a really fascinating antitrust
Yeah, it
ruling
really is.
under the Sherman Antitrust Act. And we're starting to see, back when this was enacted, when you had unions and railroads and President Roosevelt and all that stuff.
Right.
We'd kind of forgotten about what a monopoly was. And then Microsoft got hit in 2004. And, we keep hearing antitrust in the context of NIL, name, image, likeness, the NCAA.
It's an important issue. It really is.
It is. So I think you're going to see more litigation when you have someone like Google. You have organizations such as the NCAA that have such a large exclusive advantage. But this is going to be interesting. And what pundits are saying, I mean, how do you economically punish Google?
Correct.
I mean, you find them $100 million, and they're like,
Okay.
sorry, shareholders, we'll pass that on to you.
Right.
And here's our next big contract, whatever. So unless you divest them of their ability to enter in, and think about this, we're talking about the free market. Yeah, laissez-faire economics. If you're a good capitalist, you're going to prevail. So if the government steps in and says, hey, you're so good and you're making so much money, we're going to split it up and give it to your competitors, that's going to be interesting.
It's going to be very interesting. All right, when do you think we might learn something? I mean, this started in 2020. Here it is 2024, just now getting a ruling.
Well, Lori, obviously you can get a flavor for when you're talking about billions and you're talking about 90% of all default contracts and agreements. I mean, the volume of documents, technology, experts. So I think you're probably looking about 2026. But it was very interesting. I was reading the press conference that Bill Barr wrote when this justice started initiating this litigation. And, one thing the judge did not do is rule that Google had engaged in monopolistic behavior as it related to online search engine advertising.
Oh, advertising.
Because he felt that other people have kind of, businesses and entities entered that market, and I think you kind of see that when you do searches and whatever. Other people have kind of piggybacked on Google and advertising and whatever. But this is a landmark ruling that could really not only change the things for Google, but for all of us that live in our phones.
Right, absolutely. So until then, as you said, 2026, I guess most of us will keep on Googling.
Keep on Googling.
Okay, thanks for being with us. We're going to talk more about this coming up at 5:30. I hope you'll join us then.